Namaste, voice 8 from the Courtroom Voices from AAA Insolvency. The main issue involved today in the case of National Swing Thread Company Limited versus Deputy Commissioner of Income Tax and others, a judgment from Delhi High Court is whether the Income Tax Department can impose penalties and issue notices to a company that has undergone the Corporate Insolvency Resolution Process and has had its resolution plan approved, particularly in the context of the clean slate basis under the Insolvency and Bankruptcy Code. Now, the overview of the judgment is that this judgment is in the name of National Swing Thread Company Limited, challenged an assessment order and related notices issued by the Income Tax Department after the resolution plan has been approved by the National Company Law Tribunal in December 21. The company argued that these actions were invalid because under the IBC, a company that has completed the insolvency process should not be burdened with past claims that were not part of the resolution plan. The Honorable Delhi High Court agreed with the company, ruling that the assessment order and notices issued by the Income Tax Department were invalid. The court stated that once a resolution plan is approved, it binds all parties, including government authorities, and any claim or liabilities not included in the plan are cancelled. This decision follows previous ruling that have reinforced the clean slate principle. The judgment citation, it is the 24th of June 2024. It is from High Court of Delhi, the National Swing Thread Company Limited versus the Deputy Commissioner of Income Tax. In this case, an assessment order was issued on 22nd May 2024 by the DC of the Income Tax under Section 143(3) of the Income Tax Act for the assessment year 2022-23 and financial year 2021-22. The demand notice under Section 156 and the notices under Section 274 of the Income Tax Act were also issued on 23rd of May 2024. The petitioner company had its resolution plan for revival and restructuring approved by the NCLT Chennai on 6th of December 2021. Now, the area involves, this case involves the application of the clean slate basis principle under the IBC. The argument from the applicant, that is the petitioner, that is the successful resolution applicant, says that the assessment order and subsequent notices are legally untenable as they conflict with the provisions of the Insolvency and Bankruptcy Code, which envisages revival and resolution of the company on a clean slate basis. The petitioner further emphasizes that post-approval of the resolution plan, no past dues or claims which are not part of the plan should be entertained. Now, the arguments from the respondents were not there because nobody appeared from the Income Tax Department. Now, the primary legal issues revolve around whether the Income Tax Department can impose penalties and issue notices to a company that has undergone the CIRP and has had its resolution plan approved. This is again a clean slate basis. The sections that was referred in this judgment was Section 31, subsection 1 of the IBC, which is saying binding nature of the resolution plans. The other judgment which was referred in this judgment by Honorable Delhi High Court was EDO 5 River Private Limited versus Income Tax Department, and a very, very famous and Supreme Court judgment in the case of Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited and Esser Steel India Limited Committee of Creditors versus Satish Kumar Gupta. Now, the court held in this case that once a resolution plan is approved by the Committee of Creditors, it is binding on all stakeholders and any claims not part of the resolution plan are extinguished. The court therefore set aside the impugned assessment order dated 22nd May 2024 and notices dated 23rd May 2024 issued under section 143 subsection 3 and section 156 and section 274 of the Income Tax Act. Now this judgment has a lot of impact on the overall insolvency in the profession. The judgment in fact reinforces the principle of the clean slate basis under the IBC, ensuring that the companies undergoing CIRP can have a fresh start without being burdened by past claims or liabilities not included in the resolution plan. This provides clarity and security to resolution applicants and promoters of the acquiring companies, the efficient revival of the distressed companies. This judgment is in fact again relevant. It is important to the industry because it establishes that the assessment order and notices issued by the Income Tax Department were invalid. The court further stated that once a resolution plan is approved, it binds all parties, including government authorities, and any claims or liabilities not included in the plan are cancelled. This decision follows previous rulings that have reinforced this clean slate principle. This is judgment provides once again certainty and clarity. This will encourage resolution applicants to come and take over the insolvency companies. The legal protection available to the resolution applicant is very, very important. Thank you very much.